Here we go. It is Thursday. This is Why Libertarian. I am Matt. We are live with another Natural Rights Talk episode. So this is our bi-weekly series where we talk about natural rights, sovereignty, kind of the backstory of how the law evolved here in the United States. And then not simultaneously, but gradually and then all at once, all of the legal folks who were supposed to know the law completely forgot about it and don't know what they're talking about anymore. So we go through all of those step by step. Before we get rolling, like, comment, subscribe, share, notification bell, hit the retweet, get this out there. This is fantastic information. Really, stuff people think wrong about all the time because they just don't know what the actual answers are. And then a quick reminder, definitely connect with me. I always get this wrong. Over here, Why Libertarian on Linktree. Check out all of the outlets that I'm on, especially the ones that are on blockchain, because they are decentralized, they are censorship resistant, and I am doing everything I can to start to build communities on those platforms because of those very reasons. So definitely join me there, check out those, and I'm going to have some more information about some fun stuff, activities that we're going to be doing that's going to help compel people to want to be on the blockchain. So, and then next week, Monday through Thursday, as usual, I am live at 7 p.m. I actually have Jeremy Kaufman from library.com will be joining me, and we will talk Odyssey. We will talk about the Freedom Project and a couple of other things that Jeremy's involved in. So that's going to be a fantastic interview. That'll be Tuesday next week, but I have a full week plan. So definitely tune in Monday through Thursday. All right, without further ado, I am rejoined by Josiah Hinkle. Josiah, how are you, sir?
Hey, how's it going, Matt?
I am very good, very good. To remind everyone, Josiah is with the American Natural Rights. I always get this wrong. It's Foundation, right?
Yep.
I want to call it a federation for some reason, but no, it is not a federation. The American Natural Rights Foundation.
Yep.
So last week we talked kind of about the first level of hierarchy of law. We went through some of the baseline kind of foundational things. This is our second episode on hierarchy of law. So what are we going to start off on here as far as, I think we have these concepts of honor and dishonor that we're going to look at?
Yep. Yeah, so actually before we get started, if you don't mind, I just wanted to point out in the last podcast, I was talking about the civil law, and at one point I used Brazil as an example, and I just wanted to correct myself because I happened to say that they would have a degree in canon law, but it would actually be civil law. So my apologies. I didn't actually mean to say canon law. So anyways, just wanted to correct that before we got started here. But
We've cleared the record. You're good.
If you remember last time, we left off with like the American political societies had developed the philosophy to the point where the natural law was at the focus.
Yep.
And according to the natural law, that man was supposed to be free from any superior power on earth, except for those laws prescribed by nature. And so honor and dishonor is a concept as old as the law itself, but essentially it's the process that free people in the state of nature would use to interact with each other. And so to tell you about that, we got to first talk about what is a presentment. So a presentment is the act of presenting to view or consciousness, something set forth, presented, or exhibited. A presentment occurs when something is brought to your attention. For example, you are given a bill for services, you are accused of causing some harm, or you are notified of a situation. So there's 3 ways to honor a presentment and 2 ways to dishonor a presentment. Mm-hmm. And so the 3 ways to honor are accord and satisfaction, conditional acceptance, and rejection without dishonor. And the 2 ways to dishonor are through argument or through silence. So, for example, Joe makes a presentment and Sally does one of the following. She honors by accepting the presentment without recourse and then satisfies whatever is demanded in the presentment. For example, Joe presents a bill for services, Sally pays the bill. Mm-hmm. And we call this one accord and satisfaction. So the second thing she might do to honor the presentment is called conditional acceptance. Sally honors by accepting the presentment, but with conditions. Effectively, this is a counteroffer from Sally. And Joe would then accept the counteroffer as a new presentment from Sally. For example, Joe offers his house for sale. Sally accepts the offer provided that the house is first painted. And the third, rejection without dishonor. Sally rejects the presentment because it is defective. For example, Joe presents a bill for services. Sally returns the bill because there's an error. Perhaps the price is off, and she'll accept the bill once the error is corrected. Mm-hmm. So let's see. The 2 ways to dishonor. There's argument. Sally rejects the bill. There's no basis for rejecting the bill. The arguments have no relevancy to the presentment, often ad hominems or irrelevant comments against Joe. Accompany the rejection, or through silence. Sally simply does not respond to the presentment, but remains silent. The presentment is thus dishonored.
Mm-hmm. This sounds very much like, so in my daily life, I work in the insurance world, and so this very much sounds like the basics of contract law, right? So if someone is essentially presenting you with a demand or a request or something like that, you have the ability to respond accordingly. And this is basically outlining all of the different ways that the counterparty, the person on the other end of the contract, or not necessarily a contract yet because nothing has been agreed upon, but the person on the other end of the presentment can then respond in terms of whether or not they accept it. They accept it but with conditions. They reject it with, certain shortcomings that are associated with it, right?
Reject it for cause.
Right. Or number 4, the dishonorable rejecting would be like, you smell funny. I'm not going to do this, mm-hmm. right? And then the last one would just be ignoring them, right? Like saying, yeah, I'm not happy with it. Just, I'm not even going to say anything, right? Mm-hmm. Okay. All right. So that seems pretty basic. So how does that factor into court?
Well, so I was going to say, before you'd file a lawsuit against someone, you'd have what's called the administrative process or the proceedings. Mm-hmm. And so just like before, Joe makes a presentment to Sally. If Sally honors the presentment, Joe acts accordingly. So long as each party honors the other's presentments, the process can move forward to resolution. If Sally dishonors Joe, then Joe grants grace and repeats the presentment. Remember, this grace is a remnant of the Christian morality, interwoven into our system. Mm-hmm. So if Sally dishonors Joe a second time, Joe then makes an affidavit of the history of presentments. And an affidavit is just a statement of facts set under oath. The affidavit is given to a notary public. The notary is requested to make a formal presentment to Sally for Joe. Let's see here. If Sally dishonors, if Sally dishonors the presentment, the notary grants grace and repeats the presentment. If Sally dishonors the notary a second time, the notary makes a certified history of the presentments, and the history is given to Joe. So at this point, Joe and Sally's administrative process is complete. The affidavit of Joe, along with the certificate of the notary, now becomes the basis for a court action against Sally. So does that make sense?
So that's basically saying if Joe is essentially making one of these presentments and Sally decides to, so this kind of goes through, the first scenario is just simple. It's everything's taken care of. We don't really have to worry about anything, right?
Right, which is the key.
It moves to conclusion, right?
Mm-hmm.
But now we have to go through all of the different iterations of what has to happen if Sally responds with dishonor to that presentment, right? And so it seems like there's a couple of different steps that have to happen here before we proceed to an actual court proceeding.
Well, right. You can actually think of the court process as a formal series of presentments. Yeah. Each time a presentment is made, that is a court paper is filed, the responding party has an opportunity to honor or dishonor the presentment. The response, whether honorable or dishonorable in turn, becomes a presentment. Mm-hmm. So your objective is to never dishonor the other party's presentment. And if the other party persists in argument or silence, you can stay in honor by refusing his arguments for cause, stating the cause, and giving him an opportunity to cure the defects. If he refuses to stop arguing, you stay in honor as he continues in dishonor. So while you might be thinking of a court process, because that's what we were just talking about, think for a second about a time before there were courts, right? Maybe there was a tribe or like a neighborhood or a local community or something that you'd present the evidence of the proceedings to and explain the situation, and you do this to show how your liberty was violated, right? And by doing this, you'd kind of secure a sort of social legitimacy, right, that would justify your use of force to restore your liberty, right? Mm-hmm. Like if an unsuspecting, unaware third party was just to happen to come upon the situation after the fact, not knowing what happened before, they would obviously judge you for your use of force against that individual.
Right.
So doing this also might even inspire others to act, for your just cause, right? They don't want that person in the community to be doing what they're doing, whether it happened to me, it could happen to them, or, Yeah. So, but of course, to a certain degree, we have to compromise, because in the state of nature, we don't have a means to enforce our rights without risking, worse consequences. Mm-hmm. So, like, things like expense or property damage, or like imagine if you were captured, right, and enslaved, or maybe even just killed, So men leave the state of nature and enter into political society in order to better secure their rights, right? So if you're like a natural human being, right, in the state of nature, and you're self-governing and all that, and someone defrauds you, what would you do to secure your liberty? Mm-hmm. Would you use force?
Well, so you're basically saying that. Well, so the first thing I'm taking away here is that in any one of these proceedings, the goal is ultimately to retain honor, right? Like in that proceeding, because that's what gives your, I guess I'll call it a claim. Maybe I'm using the wrong word, but that's what gives your claim some legitimacy, right? As opposed to if you actively or inadvertently move into a place of dishonor, that you risk ruining the legitimacy of your claim. Right.
And the way that this works is because then we don't need courts. Everyone is able to work out every situation because they're all acting honorably. Mm-hmm. Do you see what I mean? Like if you have brought it to my attention that I have somehow done some kind of thing, like I damaged your property or some, whatever it is, that I've interfered with some right of yours, then bringing it to my attention should compel a good, reasonable person to correct it and to compensate for it. So correct it means don't do it again, and compensate for it is, make up for how you have done it. Mm-hmm. Right. And this, you see what I'm saying, rather than trying to get away with it. Right. And this is So
And so what you're basically saying is that courts effectively are there to deal with situations where individuals do not act honorably
right.
toward each other.
Or where there's a disagreement as to the fact, which is, again, why we have the jury to help decide those things.
Okay, yep.
So, like I was saying, imagine you use force against that person who defrauded you, right? Well, consider the political society that they might be a part of, right? Would that political society let their, citizen be harmed by some foreign power? No, they definitely would not suffer that. So despite your independent state, determining that fraud is illegal and that it's deserving of certain punishments, or even that, you determined that it was against God's law, using your natural, faculty of reason as a natural human being. They have armies. Like, what do you have? You know? And so essentially, like, the idea of man in the state of nature being able to secure his rights, it's not as reasonable. We have to compromise to a certain degree. So, and in fact, that's even the very reason why we continued the states and created the federal government in the first place, was because we recognized this fragile state of nature where, men have great risk in securing their freedom and liberty.
Yeah. Yes.
So without any superior power on earth to tell us what to do, honor and dishonor is basically the process that any person would use to work out any situation with someone else. Okay. So next, I guess if you're ready, I'll just keep going and tell you about the next step.
Yeah, no, that makes sense. I mean, it kind of lays the foundation for essentially why, a more formalized process of dispute resolution is where it necessarily would be required versus where it wouldn't necessarily be required.
Yeah, well, it's like the key is this, right? If everyone is acting honorably, every situation can be worked out. The only time that the situation can't be worked out is when people aren't acting honorably. And so if they're not acting, or with exception of the rejection for cause, because like I said, there could be a disagreement, right? But essentially, anyone who's not acting honorably basically demands that the society act in order to correct, basically that individual who is deciding not to act with honor, that is utilizing this system, which is just the foundational system for how humans should interact with each other, is basically calling forth, the social power to decide the matter for the person who's acting in honor. The person who's trying their best to be like, hey, did you know that there was a thing? Did you know you ordered food and I'm a waitress or maybe I'm the owner of the building or whatever, and or the business, and you ordered food and you ate the food and now you're trying to leave, but I'm trying to present you with a bill and you have to pay it. The society is basically coming out of the fact that dishonor is existing, if that makes sense.
Yeah.
So it's like, if we all want to be free in the state of nature, we all should desire and should strive to always act honorably, because then we have no need for a political society to exist, with exception of these things, how there are literally other political societies that have standing armies that would happily come at you if you were just an individual.
Right.
So, yeah.
No, that does make sense. Okay. So moving on, we're looking at why make this distinction, the difference between people versus person?
Oh, okay. Well, I was going to explain that essentially the way that the law sees it is there's what's in and of nature, okay, and this would be called the law. And then there's everything else, which would be fiction. And in other words, because it doesn't come from nature, it's not a part of the law. And because it's not a part of the law, it's not real. And because it's not real, it's actually termed legal fiction.
Okay.
So as a consequence, since governments also don't exist in nature, like you can't look out in nature and see where there's a government, right? They're also not real. They are made up in the mind of men, right? And so this excerpt that I chose here is just just decisional law kind of articulating that idea. So,
Okay.
inasmuch as every government is an artificial person, an abstraction and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. So you might be wondering then, if this is the case, then how is it that people are becoming liable to government targeting them with statutes or whatever the case may be? Well, it has to do with the way that person is defined and used in statute. So
Okay.
it doesn't actually refer to the natural person. So I have some definitions here. This first one comes from Montana Code Annotated. So again, that's where the American Natural Rights Foundation is currently located.
Mm-hmm.
So it says person means an individual, corporation, partnership, limited liability company, association, joint venture, state agency, local government unit, another state government, the United States, a political subdivision of this or another state, or any other legal or commercial entity. And so do you hear how all of those are, artificial or created entities? So this next one comes from the Uniform Commercial Code, which is just a uniform code for the laws of sales and commercial transactions. But person means an individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency or instrumentality, public corporation, or any other legal or commercial entity. And the next one comes from the United States Code. The word person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies. And this next one's from the National Labor Relations Act. So the word person, by statute, term may include a firm, labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. And so in all of these, the only thing that you could think possibly could refer to a natural human being, right, is the word individual. Right. But from Black's Law Dictionary, we've got individuals defined to be, as a noun, this term denotes a single person, as distinguished from a group or class. As an adjective, individual means pertaining or belonging to or characteristic of one single person, either in opposition to a firm, association, or corporation, or considered in his relation thereto. So again, do you see how individual is also an artificial entity that simply means a single person? So this is essentially the way, these laws are not meant to apply to, you or me, flesh and blood human beings. They're meant to apply to persons, if that makes sense. So what's more, this last one, statutes employing the word person are ordinarily construed to exclude the sovereign. So even though the sovereign is a political entity and thus an artificial person, they are normally not included within the meaning of person in the statute.
So hold on. So this kind of goes back and forth for me. So essentially, the only thing in these definitions that would lead you to believe that someone like you or I are subjected to, these statutes would be this word individual. And so as defined as an individual, the term denotes a single person as distinguished from a group or class. As an adjective, individual means pertaining or belonging to or characteristic of. So does that, I'm not connecting the dots here. Does that mean that essentially a single person for the purposes of this, or individual for the purposes of the legal definition, has to do with only when you're singling out someone from a larger group? Or is it, so for instance.
Okay, remember, if I could cut you off, I apologize for
Go ahead.
interrupting. If you remember previously, we just had it define what a person is, right?
Yeah.
So a person is all of these different things, right? A corporation, a partnership, a limited partnership, limited liability company, association, joint venture, state agency, local government unit, another state government. You hear those?
Yeah.
So individual just means a single one of those, because those are what is a person.
Okay, so what you're basically saying is that individual is descriptive of, or an identifier of, a single corporation or a single partnership or a single
Right.
limited partnership.
Right, because
Okay.
that's what a person is.
Okay. I would follow that. It also seems so. For instance, if someone were to say, "Well, no, I disagree with that. I think that
Well, this is what it is by statute.
right."
Okay.
But so what I'm saying is that last one that you have listed right there, statutes
Mhm.
employing the word person are ordinarily construed to exclude the sovereign. So
Right.
essentially that means that in excluding the sovereign, is that essentially like an inconsistency in the legal definition of what constitutes an individual or a person?
No, because remember, their defining person or individual has to do with the scope of their authority, and the scope of their authority never included or incorporated or included the sovereign.
Okay,
Does
because
that make sense? Like, that's basic
and the distinction I'm making
language.
is because in that reference, the sovereign effectively means a person that stands on their own, right? Like as an
Well,
individual and is
we'll
not a
get there.
part of any of these other
We're
things,
going to
right?
talk about that near the end. I apologize. I keep interrupting you.
That's okay. That's all right.
We will talk about that. We will define what that is later.
Okay. All right. I'm jumping the
So
gun.
no worries at all. Okay. So let's see here. Sorry, I'm just trying to see. Okay, so some terms that outline the same concept as like person from the sovereign are subpotestate, and this comes from Latin, meaning under or subject to the power of another, used of a wife, child, slave, or other person not sui juris. And sui juris, this would be the sovereign. So sui juris, also from the Latin, of his own right, possessing full social and civil rights, not under any legal disability or the power of another or guardianship, having capacity to manage one's own affairs, not under legal disability to act for oneself. So, like I said before, though, if you're just in the state of nature, you would just be called people.
Mm-hmm.
Does that make sense? So the whole,
Yes.
Word person, mixing it with people. So like we've been taught in our, common dictionaries that the singular for the word people is the word person. But
Right.
in fact, the plural for the word person is not people, it's persons.
Yeah.
You see? And so what, you might be wondering, what is the singular for the word people? Well, in fact, it's actually also the word people. So, and I've seen this, in lots of old text where it refers to a single individual as a people. It's interesting. So anyways, from Webster's 1828 dictionary, people as a noun is considered as any portion of the inhabitants of a city or country. And even in the U.S. Code, it states words importing the plural include the singular.
Yeah, so that's interesting. So
Mhm.
in a lot of cases, folks would think that if something applies to, if something applies to everyone, right, like equally, right, they would think that it applies to the people of the United States, right? But so
Right.
what you're saying is, in many cases, there can be that lack of understanding as to the singular versus the plural, right? So like if it applies to a people versus the people, those are two completely different things because you're talking about the singular versus the plural.
No, not necessarily. I mean, because you could say, Not necessarily, because you could mean all of the people, but as individuals, if that
Okay.
makes sense.
Okay, that makes
So,
sense.
like
Yep.
like the Constitution. So, anyways, so let's see. Sorry, where were we?
Starting
So,
with republic
yeah,
versus
yeah.
democracy.
So, how another way that we know that the common vernacular, the people, refers to the singular, right? Rather than the collective. That each individual people is a sovereign of the American government, is from comparing the definition of republic with that of a democracy, no less. So
Okay.
when we look at the definition of republic, we see a form of government in which the powers of sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people, to whom those powers are specially delegated. And so democracy is defined to be that form of government in which the sovereign power resides in and is exercised by the whole body of free citizens, directly or indirectly, through a system of representation, as distinguished from a monarchy, aristocracy, or oligarchy. And so what you're seeing in there, since we have a republic, our sovereignty is not in the whole body of free people, but rather in each individual, right? And so this idea of democracy actually comes from our representatives. All of them, or a quorum, which is just essentially enough of them to constitute all of them, vote, right, with an equal vote, and they all rule by majority rule. So very much so, like our government organization is democratic, but that idea is contained within the republic, which is the government that we actually have.
And to that extent, so, and forgive me if I'm maybe jumping ahead or not fully kind of enunciating this correctly, but so that also essentially means that the idea that we live in this, and I think the buzz phrase that is always taught to everyone is, okay, we live in a democratic republic, all right? And so I think folks just the layperson misses the fact that that democracy piece only really applies to the representatives, or at least it more. Well, so the democracy, or the democrat. Let me say the democratic process, right? More often than not, plays out in terms of the representatives that are then voting on certain things, whereas the republic piece of it still prizes the individual above that process. Am I saying that correctly?
And the way that you know that is because when you look at the definition of person, it's not people. You see what I mean? The persons they're trying to regulate, that is the persons that the democracy is in control of, are not people. They're artificial, imaginary, right, creatures of the mind, as we discussed in the beginning. Yes. That being the only kind of individual or entity that the government has the legal capacity to interact with.
And thereby the only true collective or group of fictions that the government has direct control over or direct regulatory oversight over. Would you say that's true?
I missed it. What was?
I'm saying, or another way of also saying that, say, like the government as a fiction, essentially, right? Only really has dominion over or direct oversight over those other fictions, right? They don't
can only interact with. The dominion has to do with whether those fictions come from that one's authority,
right?
If they're subordinate to, yeah.
And so in that case, there's no real direct control or oversight over the people,
right?
Jurisdiction would be yes, that's probably a better word.
The way that works is that they would have, or for the people who are free sovereign people, or rather free people in the state of nature, or like it says, not considered the sovereign, not considered within the term person, in statute. I mean, you would consider. Oh shoot, I lost my train of thought.
That's all right.
sorry about that. Can you remind me what we were just?
Yeah, so just in terms of talking about like, jurisdiction over the people versus, jurisdiction over a sovereign not necessarily being not just the intent, but even possible, right? Like, so a
Right,
fiction can't necessarily have direct oversight or jurisdiction over the sovereign.
right. That's correct. And we're going to actually, like I said, we're going to actually more clearly define and talk about some of the dynamics that have to do with sovereign power.
Okay,
And
awesome.
again, so that remember where it said that in the definition of a republic, it said it was specially delegated. It said to
To
whom those
whom those
powers are
powers.
specially delegated. Right. So what that's saying is that there's a particular sphere of authority that has been given to them. Right. And anything that comes or within that sphere of authority would legitimately be exposed to the liability of that authority.
Mhm.
Okay. Anything outside of it, obviously, which would include the people or the sovereign, would not be exposed to any liability to it. So there were two dominant political theories, and they one of them was the Republican. And this is where legitimacy was based on the degree of alignment with the natural law. And so those whose political philosophy believed that the answer to any issue was in the absolute security of individual liberty. And remember, that's anything that your inclinations may suggest if it's not evil in itself and in no way impairs the rights of others. So again, if it doesn't impair the rights of others, there's no reason to be regulated, right? And I think this idea of is not evil in itself is like imagine you might have heard that I don't even remember which one, but whether it was like Rothschild or some banking elite, whatever, put out rumors about who had won the war, that Napoleon had won the war, and that this caused like a serious tanking in like English stocks, and as a consequence, he bought up. He made himself super rich, and everybody, lost a whole bunch because they all believed this rumor that him with a lot of clout was able to spread.
Right.
So like this to me, I think is what that phrase, if it's not evil in itself, even though it didn't necessarily take away from the rights of others, I think this is what it's saying. You know what I mean? By saying it's evil in itself is not something you have a right to do. But
Okay.
anyways, yeah. So the competing political philosophy was federalism. And so for a federalist, legitimacy was based on vesting the sovereign power with an absolute authority over the states. Those whose political philosophy resembled that of England, which vested absolute political authority in the king. And so many of the Federalists maintained the old convention that the political elite were necessary to, save ignorant and uneducated mankind from itself, basically. And they would end up utilizing this democratic aspect of our government to usurp the power of the federal government and expand it, in fact, illegally. So yeah, next, if you want, we can just get right into sovereign power. I know we've been itching at it the whole time.
Yeah, no, and just before we get into that, I find, just to draw a parallel to, I think, some of the ignorance of the day and age, I think a lot of people would point to the government that was put in place by the Constitution, and you hear a lot of this from the folks that are, talking about this, kind of like the United States being born out of this kind of like, they'll say, white supremacist or racist kind of origins and things like that, and there were those elements to them, and so this idea that like, the regardless of what you call it, the idea that Federalists would keep those like wealthy elites in place just in case like the idiots decided to do something and blow up the world, so to speak, or like ruin things, right?
Sorry, I thought you were going to say
Yeah,
something else.
no. So and the irony is that folks will point to that and say that that was the way things were set up, and then they will defer to rich like aristocrats in order to remedy the situation. But so I think that's the one piece that I would say is like one of the things where, like, if I identify someone as a federalist thinker, I'm immediately turned off to them because they are essentially they are not a believer in the individual, right? They are a pessimist of the individual, or at the very least, they believe that it's potential. There's potential there for the individual and collections of individuals to cause harm to the country or whatever kind of like dominion that you're looking at.
I think, if I might,
Go ahead.
I think it's actually maybe a difference between the Republican that is that one that would hold individual rights absolute, right, unconditional, no way to impair or affect them. I think it's that person has a faith or some kind of confidence, right, in the law. And I think this other person, and when I say the law, I just mean justice, right?
Yeah.
I mean righting wrongs or keeping wrongs from happening, right?
Yep.
Whereas over here, I think these other people maybe don't even know about the law or don't trust the law or don't consider the law. But to them, their solution, because it doesn't come from the law, is a very powerful government and a very controlling and decisive government, right?
Yeah. Yes.
So I think that's the fundamental. And so then, yeah, obviously they're absolutely at odds with each other.
Yeah. And also the federalist way of thinking almost being at odds with nature, right? Like,
well, right, because the idea here is that the natural law is the epitome of what makes man happy, right? And again, we're not talking about, we're not. I think that could be abused a lot. This idea of what makes man happy, right? Like, what if it makes me happy to cut your head off, right? Well, again, that would either be evil in itself or that would impair the rights of others. So it wouldn't actually be a natural right at law. And again, we're all trying to act honorably. So even if your actions come to the harm of another person, you would be there right there, happy to fix it and to correct it. If you get in a car wreck with someone, like, are you unhappy that your insurance pays for it? Like, aren't you, if you caused that wreck, like, or if you didn't even have insurance, would you not pay for it? You wouldn't try to get away with what you've done. You know what I mean? So, like, yeah, anyways, I just see the natural law as being, the epitome of that entire relationship between acting honorably and the fundamental pursuit of man's happiness.
Definitely.
And definitely that being contradictory with the more primitive concept of powerful government corrects all wrongs.
Yes. Yeah, most definitely.
Yeah.
All right, so we've been dancing around it.
All right.
Sovereign power.
All right, sovereign power. So there's a maxim is a word you might have heard before, but it's essentially just a legal principle. But a maxim is so called because its dignity is chiefest and its authority is most certain, and because it is most approved by all. So a maxim relevant to our discussion here is the power which is derived cannot be greater than that from which it is derived. So it doesn't matter that they expanded their authority or their powers because they didn't have the authority to do so. And also the extension of that power over the sovereign is ludicrous because, again, the sovereign is the source of that power, right? The sovereign is the one with the power who gave that specially delegated power to that, person, that individual. So sovereignty is the supreme, absolute, and uncontrollable power by which any independent state is governed. The right and power of regulating its internal affairs without foreign dictation. The power to do everything in a state without accountability. And so I have some relevant decisional law here about sovereignty that's pretty self-explanatory, but feel free to stop me if you have any questions or if you want to talk about anything.
No, let's power through this.
All right, so the sovereignty of it. Sorry, were you going to say one more thing?
No, I was just going to say I think the examples will hammer it home. So yeah, okay. Definitely don't let me stop you.
So the sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people from whom the government emanated, and they may change it at their discretion. Sovereignty, then, in this country abides with the constituency and not with the agent. And this remark is true both in reference to the federal and state government. The words sovereign state are Kabbalistic words, not understood by the disciple of liberty who has been instructed in our constitutional schools. It is our appropriate phrase when applied to an absolute despotism. The idea of sovereign power in the government of a republic is incompatible with the existence and foundation of civil liberty and the rights of property. And I want you to remember that later, right? The idea of sovereign power in the government.
Well, it's also the ridiculousness of calling it sovereign immunity when you're essentially giving immunity to a government body, right? The government body is not the sovereign. The sovereign immunity is supposed to be applied to the individual. But yes, yeah.
Right. But anyways, we're going to expand on this later, this idea that sovereign power in the government of a republic is incompatible with the existence and foundation of civil liberty and the rights of property. We're going to see how that very fact comes to real material realization in our law and legal system. But that's for the next time.
Okay.
So at the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern but themselves. People are supreme, not the state. In the United States, sovereignty resides in people. The Congress cannot invoke the sovereign power of the people to override their will as thus declared. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. The very meaning of sovereignty is that the decree of the sovereign makes law. And if you think about the King of England, right, he simply speaks and everybody has to obey him, right? So that makes sense. But in America, it's actually similar. So if you remember the last time we talked about when a plaintiff files his first cause of action, there's that remember the authority of his claim is based on that detailed section called points and authorities, where basically the points he'd make, which were based on reason, and the authorities he'd cite. So the points and the authorities would both basically act as the decree of the American sovereign, right? And it's not a decree that has to do with controlling everybody, right? They don't control everyone. They just they have the power to define the injuries that are done them, right? So when I say power, I also include right. So the right and power to define the injuries done them. Basically this, along with the constitutions, would be the sovereign people exercising their powers directly. The doctrine of, and I don't mean all of their powers, I just mean that particular power to legislate. So the doctrine of sovereign immunity is one of the common law immunities and defenses that are available to the sovereign. And the last one, even if the tribe's power to tax were derived solely from its power to exclude from the reservation, the tribe has the authority to impose severance tax. Non-Indians who lawfully enter tribal lands remain subject to a tribe's power to exclude them, which power includes the lesser power to tax or place conditions on the non-Indians' conduct or continued presence on the reservation. The tribe's role as commercial partner with petitioners should not be confused with its role as sovereign. It is one thing to find that the tribe has agreed to sell the right to use the land and take valuable minerals from it, and quite another to find that the tribe has abandoned its sovereign powers simply because it has not expressly reserved them through a contract. To presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserves the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head.
Yeah, so that idea being that in this particular case, having to do with more so the merits of tribal law and property right, essentially is discussing taxing those that would come on and use the property, but at the end of it, it's basically saying that, say there was no official communication made, you can't just automatically presume that the sovereign is waiving its rights unless it expressly says it is.
Exactly.
Right?
Exactly.
Yeah. And And so, like, you can't just, I mean, the same would be true of anyone's property rights. Like, just because there's no fence up doesn't mean that you can just wander onto someone's
Exactly.
property and use it
Yep.
as you see fit. Yeah.
Because it's a logical distinction, not a physical one.
Okay.
Yeah, spot on with that. And in fact, I'm so excited. I can't wait till we get through the other information that I think should come first. But we're going to talk about what makes a valid waiver. It's one of my favorite things. But yeah, so the next section, it's just like the others, but it's all pretty self-explanatory. But you can feel free to stop me, So unconstitutionality. The sixth article of the Constitution of the United States declares that the laws made in pursuance of it shall be the supreme law of the land, anything in the Constitution or laws of any state to the contrary notwithstanding. By this declaration, the states are prohibited from passing any acts which shall be repugnant to the law of the United States, which pursue the Constitution. And I'm going to actually skip the next one because it essentially says what that says. So the third one, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. In declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. So remember, I just want you to see that basically every time you've ever heard a decision come about, and you're like, what? That is obviously not correct. That violates an amendment, say, right? It would be, right, subordinate to all the rest of the laws, right? It would not actually have the same controlling force at law because it's a subordinate authority. And in fact, like this is saying, if it's in fact violative of it, it's entirely void. It's not even just,
well, yeah,
lesser affected. It's literally irrelevant.
It's essentially giving a rational explanation why unconstitutional laws should just be ignored.
Yep,
right?
Exactly.
Like, they have absolutely no credible standing, and therefore, you can essentially act as if they just don't exist.
Mm-hmm. Yeah, here, yeah. Let me read on. You're gonna love this. So it's to continue that one. It says all laws which are repugnant to the Constitution are void. So I keep losing my place. Since the 14th Amendment to the Constitution states, no jurisdiction shall make or enforce any law which shall abridge the rights, privileges, or immunities of citizens of the United States, nor deprive any citizens of life, liberty, or property without due process of law, or equal protection under the law. The enumeration in so that one is essentially just like in the positive law, all of those same rights being secured that existed in the natural law. And one thing that I found interesting when kind of researching about political theorizers of the natural law is that they would say that there doesn't need to be a positive law that mirrors any natural law, and that the philosophical argument for this is that no laws of man can give any more force or right to the laws that God has already established. So that's why you won't find, it's against the law to murder someone in England, because that's just against the general law, or against, the universal law, rather than needing to be against the particular laws of England, the particular positive laws, right, of the government of England.
Right.
Anyways, let's see here. So the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so that's the U.S. Constitution. That's the Ninth Amendment. So basically, by this, all rights that are retained by the people are constitutionally protected rights. Okay? This is why I think the Ninth Amendment, I understand a lot of people give a lot of focus to the 10th Amendment, but honestly, I feel like the Ninth Amendment is far more powerful, because if you're not a state, I mean...
Well, yeah, and so essentially the Ninth Amendment is it's essentially stating the sovereign nature of the individual, right? And essentially saying that
of the people,
or the 10th is simply talking about, essentially the balance of power between the state and the federal government. This goes all the way down to basically the ground floor, so to speak, the foundation of the country, saying that essentially, you're not allowed to deny or disparage others, retained by any of those rights retained by the people, and that would be superior, like from a hierarchical standpoint, than even the 10th Amendment or any of the other powers that are ceded to the federal government. I agree with you
if
there.
you remember, I don't have the 10th Amendment up here, but I'm pretty sure the 10th Amendment in the second part of it says "or to the people." So it also is inclusive of that. But you'd be absolutely right when it came to you got a vaccine law coming about, or you got some gun rights laws coming. Like all of that would absolutely be, included within what you're talking about.
Yeah.
Mm-hmm. So let's see here. So where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. So remember, you might have remembered last time we talked about administrative law or policy. So that might be what they're saying, rulemaking. So legislation being the statutes, the codes, and the rulemaking is or even if it's just like local custom, right? Mm-hmm. That would all be included in that, saying it cannot deny, or that it cannot, it cannot abrogate them, cannot abrogate constitutional rights. So an unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation, as inoperative as though it had never been passed. So pretty powerful, but very obvious and, unavoidable in my eyes. You can't really get around that, And this particular clause here, it creates no office. Remember that this is a reference back to, color of law, that you cannot, under color of office or color of any statute, infringe upon people's individual rights or liberties. And no amount of a thing written on a piece of paper, when it is violative of the Constitution, affords an individual that office, right? Or that what that's saying is that power.
Yeah.
So a practice condemned by the Constitution cannot be saved by historical acceptance and present convenience. So you think of slavery with this one, right? It was not saved by historical acceptance or present convenience. So I think about the natural right to use an automobile, right? So what this to me, I understand that if this was to be ended, the state would be so drastically impacted by the loss of revenue, right? That it would have to drastically reconfigure what it was going to do, replan and everything. And I'm okay with that. The same way that people, who were fighting against slavery would, the Southerners were like, yeah, but all our money is tied up in the slaves and they do the work on the plantations. And so all of our businesses are tied up in the slaves. And so the North are like, yeah, we get that. We don't care.
Yeah. Yeah. Well, and that's also interesting because so a lot of times, say at the Supreme Court level, they will talk about, and I forget what the term is, but essentially the idea that if they were to find something to be constitutional or unconstitutional, it comes about in terms of when they were talking about Amy Coney Barrett and if any of these Affordable Care Act cases make it to the Supreme Court. And during her questioning, they basically, during her vetting, they questioned her and asked if she would take into account the potential impact to individuals if, say, they had become reliant on something that was unconstitutional, right? Which is interesting because here it's basically saying that regardless of historical convention, it could go back from this beginning of time, but just because it's been around forever does not mean that it should be preserved despite being unconstitutional, right?
It also says or present convenience. So there's no argument about but it would really suck to do that. That's not an argument. That can't stand. There's no legitimacy there.
And this
Like
is a fairly
convenience.
recent, I mean, like 1984 is fairly recent historically in terms of legal precedent. So,
Right. So let's see. The statutory procedures reflect the obvious concern that there be no sanction or penalty imposed upon one because of his exercise of constitutional rights. It's been long established that a state may not impose a penalty upon those who exercise a right guaranteed by the Constitution. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. The general rule is that the unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. And so this to me is just like, it's right on point saying that like at every level of our political society, we have the power. Every single individual is empowered to refuse to enforce or judge or act on unconstitutional things. So if there's a whole bunch of unconstitutional stuff happening, it's either happening through ignorance or it's happening because there are that many corrupt people in existence. And I would imagine it's the ignorance, but that's what it would have to mean. Let's see. So a constitution is designated as a supreme enactment, a fundamental act of legislation by the people of a state. A constitution is legislation direct from the people acting in their sovereign capacity, while a statute is legislation from the representatives, subject to limitations prescribed by the superior authority. The authority of legislation in the state government is not unlimited. There are several limitations to their legislative authority. First, from the nature of all government, especially of Republican government, in which the residuary powers of sovereignty, not granted specifically, again, you hear that, specifically, by inevitable implication, are reserved to the people. Secondly, from the express limitations contained in the state constitutions. And thirdly, from the express prohibitions to the states contained in the United States Constitution.
So a lot of this continually comes up, right? I'm going to ask you more of a in practice type of question now. So this continually comes up through this case law, the idea of essentially the laws or edicts that or constraints that are essentially against the Constitution and also therefore or not also therefore but and also against the rights of the sovereign, right? The natural rights of the sovereign, that they are essentially invalid. They should not be enforced. The sovereign should be able to effectively ignore them and not necessarily have to abide by them. So what would you say to someone who says, oh, well, the Supreme Court saw this case and they said that it wasn't a violation of the Constitution? Would you then take them the route of saying, well, even if they don't find that it violates the Constitution, there is also essentially the hierarchy of law that says before you even get to the Constitution, you have to start with natural rights before you even talk about whether or not something is constitutional or not.
True.
Is that the direction you would go with that?
Well, I would actually question the cause which allowed them to determine it was unconstitutional. Because if you thought it was, then maybe there was actually something unconstitutional there. And if it was truly in substance unconstitutional, then that would just be another bad decision.
Yeah.
Right? Another decision that has no force or effect. He would just be included in with the corrupt. And so you might go after it with a counterclaim, making him a defendant, saying, by what right do you have to bring me into this court? I'm going to bring you, I challenge the jurisdiction. I demand to be released from it. I'm actually going to sue you in this court of record on the basis of having no jurisdiction. Now, later we're going to talk, potentially we're going to talk about some other kind of process. This is what we've been working on, but we might actually have different things to offer in the future. But essentially what we've been working on, it would be this countersuit in a court of record. And that, person who was the judge who decided it wasn't constitutional would simply be included in the defendants, the list of defendants you were already,
I I can't wait for the first action taken directly against a Supreme Court justice
Right?
based off the fact that they found
That'd be
something
great.
to be constitutional. And someone argues they have lack of jurisdiction. I think that's also the other thing that I think about is more kind of like the maybe it's the anarchist in me or whatnot, but I go back to our first conversation and just talk about like, well, this thing was never re-ratified or repassed after the first generation, so therefore it's not even a valid contract anymore.
Right.
Like,
We're going to talk about that next time when we talk about what is a citizen. And basically, well, yeah, I can save it for later. We can talk about it now. You let me know.
yeah. Well, I mean, you can preview if you want, but I definitely don't want to steal our thunder from next week.
I mean, there are very, very old cases where Supreme Court cases where judges have determined that to be born, on the soil, there's old common law principle just solely that if you're born on the soil of the territory which the sovereign, controls, then you would be considered a citizen by common law. And two issues with that, though, is that, well, first of all, so if you were born on this soil, right, the idea that you're a citizen would actually be true because you're not actually you're a human being, but you're not actually an adult, right? And the difference between a baby and an adult is real in the law, right? Babies can't do anything for themselves. So in fact, the state has always been empowered under a principle called parens patriae to take over, control of, I think it's infants, idiots, and lunatics, which is the old English of, basically saying, infants, people who are too young to be able to have discretion in, action, and idiots, so people with mental handicaps, and lunatics, also people with mental handicaps, right? So essentially, the state has always had the right to intervene in their behalf, right? And the other thing to do with it, so basically their idea is that, if you're born here, you would be, considered, you would be considered not necessarily under the control of the government, but the government would be acting in your behest, right? And so that makes sense. But again, once you come to years of discretion, that would lose its art. It's, if you're not, mentally handicapped or mentally ill, then that would lose all its force, right?
Right.
And the only thing, like you were mentioning before, the only thing that could then bind you would be the act of your parents. But again, when you come to years of discretion, if you're not represented with that option, and that option is essentially, it's not which candidate are you going to vote for or which political party are you going to be. It's whether you want to be under the control of that government or not. And that question, if it's answered one way or the other, either gives you legitimate government, a de jure government, or an illegitimate government, a de facto government, a government by the fact that they have power to act as if they were in control of you.
Yeah. Well, we can definitely cover that in more depth in the next one or two episodes here. So, no, I think the effectiveness of this information, I think, is really important in terms of establishing the true line in the sand, right? So, like, I think for a lot of people in practice, this idea of trying to think of what is natural law or the natural rights of a human being, right? Like of an individual or of a sovereign.
Well, remember, it comes down to those three things. Anything that your inclination suggests, if it's not evil in itself and in no way impairs the rights of others. So I could agree there's some discretion that could be applied to what it means, evil in itself. But I did try to give that example that I think there are things you're going to see that fundamentally affect, humanity, but aren't necessarily a particular infringement of others' rights. And so while you have, that last clause that it in no way impairs the rights of others, you have this other thing that says it's not evil in itself, but essentially anything that your inclinations suggest is what is appropriate in the natural law. Again, considering everyone to be acting honorably, you have no reason to control anyone.
Yep. Yeah. No, I think that's this subject matter, I think, is good from the standpoint of it gives people an opportunity to have a little bit more of a not concrete, but something they can wrap their heads around, as opposed to that kind of like ethereal manifestation or enacting the sacred phrase of like natural rights.
Mhm.
And so I like that. So we're continuing to kind of like build the bricks as we go,
Yeah,
which is fantastic. So, all right, cool. We're gonna be back in 2 weeks with another one of these. Your endeavors right now with ANRF are still in the research phase, right? You're still kind of going
that's
through things.
correct. It's possible that soon, if we're kind of looking into new leads that you yourself are aware of. But
Yep.
depending on how those turn out, we might actually be moving into phase 2 pretty quickly. And included in that would be offering public classes, essentially. Start teaching people. Like, this is more or less like fundamental philosophy, right? That's
Yeah.
what we're trying to teach here, to give people the idea of being able to make determinations and assertions based on their own reasoning and merit, right? Or the merit of their own reasoning. They don't need to go and look, what did they say? What did they say? What did they say? No, that's not what we're talking about. What we're talking about is what's reasonable to us. What did our inclinations say to us was reasonable, that in no way impaired the rights of others and wasn't evil in itself, right? You see what I mean?
Yep.
And so, yeah, so being able to give them that kind of like grounding, that now no one can then come and be like, oh, well, we voted on this, and that means that you'll be like, no, it doesn't. Your vote is
Yeah.
irrelevant. It's basically
Yeah.
useless. We can ignore it. Thanks for wasting your time on something that was irrelevant instead of something that actually mattered. Because
Yeah.
now we can just ignore you instead of having to actually deal, with whatever you had.
Yeah.
And the other part of it, if like I was saying, this new lead kind of pans out the way that we think it will, we might actually be able to provide the more of the procedure, right? What you're actually going to go and do in order to affect your situation, rather than the philosophy which legitimizes your situation, or what you would
Yep.
do about your situation.
Yep. Yeah. No,
Yeah.
I'm looking forward to that. And yes, we have someone that we're looking to talk to that I think
Yeah.
has that procedural thing down, or at least is working it out. So
But yeah,
that
it's basically like there are all sorts of, what I found in kind of taking these things to court was there are all sorts of things that bind. Like, look, everything I've read to you is from the law. I didn't
Yep.
invent any of this stuff. This is literally all written. It's all right there for you. You know what I mean? Like, if you just go and you research the law, you know what I mean? There's so much stuff, but in particular, there's all these different bodies which basically create that administrative law I was telling you, right? It's the law for, the artificial entity for government agents usually. And
Yep.
so it's basically the policy they use to do, whatever they're doing. And so, oh shoot, of course I was going to lose my train of thought. Sorry, I'm really tired today. So
That's okay. I no, but that makes sense. It's the idea being that we lay the groundwork with the philosophy and with kind of the foundational knowledge, and legitimize the standing for saying these things, and then like you
oh,
said, we start to get into more application to essentially like you were talking about. There's literally numerous ways that you can essentially work within the process right now because
mhm.
it's so broken, but you can exploit those aspects of the process in
And
order
like
to
I
get
was,
to an
I was
actual
going to
good
say, I'm
resolution.
sorry.
Go ahead.
I remembered what I was going to say, but it essentially, when you are, looking around at what there is, you'll find there's all sorts of groups, or like I was saying, like bodies that take it upon themselves to create this administrative law for those more subordinate entities. And I mean, they're great. Like, the kind of demands upon a public official that are actually written are so extensive and like intense. Like a judge not only has to avoid impartiality, right? So that is giving preference, uneven preference. Okay, partiality is giving uneven preference. He has to not only be impartial, right? He has to be a judge who's not going to give preference to the parties, but he's got to avoid even the impression of impartiality. So he can't even be seen going into a particular place because it might give the impression that's against the code of judicial conduct in some states. So like, you see what I'm saying? Like the things that already exist in the law, that there are particular bodies that literally got together to make administrative law for those entities. They're just, it's pretty good what you can do to them.
Yeah. Well, we're definitely going to go further down the road of providing some more foundational knowledge, as well as potentially getting into at least a couple of those, application type situations, or what they might look like in general. So, a reminder, everyone, if you have made it to the end of the recording, or if you're still with us live or watching the recorded version, remember to hit the like button, helps us with the algorithm, and subscribe. Josiah is going to be back in 2 weeks on Thursday night at same time, and we will talk some more natural rights. So with that, this is my last show for the week. I'm not doing Fridays anymore, so it's almost like a 3-day vacation every single week now. I can go back and work my 9-to-5 job now.
Oh, nice.
So, look, Josiah, have a good evening. Everyone else, have a good evening, and I will see everyone Monday.
Thanks so much, Matt. Have a good night.
You too.